Welcome back to my amalgamation edition, and this is the second part. And we had already dealt with section the overview of the CAA and the forms which dealt with the basics and 230 and 232. Don't forget, early we completed 3 forms: NCLT 1, NCLT 2, and NCLT 6. And here there are other CAA forms. Now we'll start the second video session from section 233. Very important for exam point of view. And this section 233 deals with the amalgamation, a merger or amalgamation of certain companies. And this section, certain companies, this amalgamation is called as, or this merger is called as fast track merger. You can use the word merger or amalgamation interchangeably, because in the new law, both the term has been used synonymously, because you can use interchangeably, no issue. Coming to what is a fast track merger under section 233, that is merger or amalgamation of certain companies. There is a unique provision which is introduced in the Companies Act 2013, which says if it is an arrangement, compromise or amalgamation between two small companies, one category. Second category is between a holding company and its wholly owned subsidiary company, OS. Then you have an option to use section 233 in spite of or not using section 232. So 233 is an optional section where if it is an amalgamation or CAA between small companies, or that's the first category, and second category is it's a CAA with a holding company and its wholly owned subsidiary company, WOS, then you can use the easiest route, that is the fast track merger route under section 233. I remind you, section 233 using is an optional. The same small company amalgamation can be done in section 232 also. The same amalgamation between a holding company and a wholly owned subsidiary company can also be done in section 232. Depends on the circumstances. So this is an easy route which is an alternative for section 232. Right? What is the crux of section 233? There is no approval, statutory approval, which is required from the National Competition Tribunal. Here the approval of central government is required. It does not require the approval of the National Competition Tribunal. So that is the procedural aspect is liberalized here. Next slide. Again, here you have to call the objections from your members and creditors, and that objection, the notice and the objection, that is the meeting notice and the objection, should be called in form CAS 9, and the objections period is 30 days. Here the scheme at the meeting has to be approved by 90% in value. See, in 232 or 230, the approval is required by way of special resolution, unique special resolution. You know that 75% in value representing majority number. Here there is no such complication. Here the approval value is 90%. So we cannot call it a special resolution, because special resolution is 75%, right? Or above, typically in a traditional way. Here the approval of the shareholders and or creditors is required with the value of 90%. So that is very important. That is a change from an ordinary amalgamation and a special amalgamation under the section 233. Here, being an easiest route, since you does not require the approval of the National Competition Tribunal, here there is an additional compliance which is called as a DOS, that is a declaration of solvency. Every company is involved in fast track merger should file a declaration of solvency in CAR 10 form with the Register of Companies, and the meeting should conduct, and the meeting should approve the scheme with 90% value. The shareholders in having 90% value should approve the scheme, and the report or the minutes of here this meeting, that under section 233, should be filed with the ROC in form CAA CAR 11. Again continuing, if the central government, after hearing the matters, if there is nothing has to be complicated, then the central government will confirm the order, will be issuing a confirmation order, will make through the amalgamation, fast track amalgamation, and that order will be in CAR 12. But in contrary to that, if the central government feels that public interest has been affected, tampered, then it will not issue such an order, but rather it will approach the Honorable NCLT. Here require, see here, mind you that here NCLT will come, because why? This fast track merger is not in public interest. Now you will take a U-turn. Then the central government will file an application with the National Competition Tribunal in form CAR 13, and the National Competition Tribunal, after hearing the parties and after hearing the companies, if it feels so, there is no issue, then it will confirm the order. But if it feels so, there is some issue, then National Competition Tribunal will order that this amalgamation should be in the normal route. What is the normal route? Under section 232. Got my point? So in last there is a, like a film, last there is a twist here. Because why? If it's everything is okay, the central government will approve. If central government is not approving it, and if it reserves for some public interest issues, then it will apply to the National Compellent Tribunal in CAR 13. And the National Compellent Tribunal, Honorable Tribunal, if it feels there is no issue, will confirm the order, no issue. But if it feels that there is some issue, then it will order that this amalgamation should not be passed through in a fast track route, but it should be in the normal route under section 232. Got it? So that's it. Moving to last but one section. This is very important section for CA final because institute usually asks from this section, section 237, which speaks about central government's power to amalgamate companies in public interest. Mind you, here the central government does not want two government companies. It does not require the condition of a government company. Any company, the Act used the word any company. So central government is empowered under section 237 to amalgamate any company in public interest. Basically here there is no scheme because there is no compromise or arrangement. That whole edifice of this section is public interest. So central government voluntarily picks up two companies in public interest and decides to amalgamate the same by issuing an order in the official gazette. But natural justice has been served. Before issuing such final order, the central government will give you the draft copy of the order, will send to both the companies, and both the companies have the right to object the same. And if there is no objection, or after hearing everything regarding the exchange ratio, purchase consideration, everything, the final order will be passed. And the final order so passed by the central government, after notifying in the official gazette, will be placed before the both houses of parliament, so that the whole system should know about such amalgamation. So this is the simple section 237, very important from exam point of view. You must look into this detail, and you must also understand the comparison between the normal merger, fast track merger vis-a-vis central government initiative merger. Got it? Coming to the last section, preservation of books and papers of amalgamated company. This is very important because you know that by amalgamation what will happen? A company, that is the transferor company's life will end, because since all the assets and liabilities of A company has been transferred to B company, there is no purpose of A company, so it will be dissolved without following a winding up process. Why should we do a winding up process? Because the company does not have assets and liabilities. Assets and liabilities has been transferred to other company. For that you got money, you got purchase consideration, you got the exchange ratio. So in nutshell, there is no purpose of that company. So the company will be dissolved without following a winding up process. Now the question is, what will you do with the books and papers of the amalgamated company? The law says, before disposing the books and papers of the amalgamated company, the central government's permission is required, and the company should apply to the central government to how to dispose the same and the modus operandi of the same. Central government has been empowered under section 239 to appoint an investigating authority to see whether the company is involved therein has indulged in an offense or fraud has been committed by the companies either in the promotion stage of the company, formation stage of the company, management stage of the company, or amalgamation stage of the company. If anything is been happened, then the matter will go accordingly. Maybe it may lead to some investigation further on. If there is no such instances, and if the investigative authority gives a clean sheet, then the books of accounts and the books and papers can be amalgamated as per the terms and conditions, as per the modus operandi which has been ordered or sanctioned or permitted by the Honorable Central Government. So this will do the magic of whole compromise amalgamation arrangement. I told you in the introduction video, first video itself, that this is not the only things we have to study, but this is the crux of studies. I will give you a bird's eye view again. Section 230 to 240 of Companies Act deals with CAA, read with Company CAA Rules 2016. Section 230 is very important, gives the power to the company to enter into compromise arrangement and amalgamation. Section 231, it's a procedural aspect which we don't want to be that much dealt with. Section 232 is a very important section which specifically deal with amalgamation. Got it? Order of amalgamation is issued in the case of compromise and arrangement in form CA 6 by the tribunal, and in the case of amalgamation in form CA 7 by the tribunal. Apart from the normal, the cumbersome procedures under section 232, you can prefer 233 for certain companies. For small companies amalgamation, for amalgamation between a holding company and wholly owned subsidiary company, they can use the easiest route, that's called the fast track merger under section 233. But here the approval at the meeting is 90%, but there the approval at the meeting is 75% with plus majority number. Mind you that. In normal merger, you require 2 times. First time you have to file a petition to the National Competition Tribunal for convening the meeting, and second time you have to file a petition for sanctioning the approved order. Got it? And then we have to study is the amalgamation in central government initiative, that is only under the ground of public interest. Central government is empowered to amalgamate any companies in public interest so that the public interest will serve. There also there is no scheme and no approval of the Honorable National Competition Tribunal is required. That is at the instinct of the central government, and that is by way of publishing an order in the official gazette. But they will give you an opportunity to object the same, and the objections will be looked into. The purchase consideration will be an issue. Then the compensation will be fixed by the central government, and that will be paid by the transferee company. So this is the whole. Before I conclude this video, I like to request my students to refer many case laws. If it is by regular class, I will be teaching you around 25 case laws, including Honorable Supreme Court case which is very important, Mir H. Mafatlal versus Mafatlal Industries Private Limited, which is a very important case, because in that case, the law says, the Honorable Apex Court says that in considering the petitions, the courts or now the tribunal don't forget the concept of public interest. The scheme should be sanctioned only if it is fair, only if it is reasonable, and only if it is in the best interest of the public. This case is very important. And you have to look into the another case, which is Jagran TV case, and also that is the another case which is along with the Jagran TV is the Sony, company's case, which is very important, which speaks about the applicability of accounting standard 14, and it says that accounting standard 14 is not that much applicable to the demerger. So if it is a demerger scheme, non-applicability or non-compliance with the accounting standard 14 will not make the scheme invalid. It will make the scheme valid. That is very important. And you must understand, another case is very important, is that here the transferor and transfer company which we are speaking should be very important, because the transferor company need not be a company under the Companies Act, but transferee company should be a company under the Companies Act. What does it mean? Even a foreign company can be merged with an Indian company. Even a partnership firm can be merged with an Indian company. Even a non-body corporate, that is not a company, can be amalgamated with the Indian company. Why? The whole concept here is the transferor entity need not be a company as per the Companies Act. Maybe or may not be. But transferee company should always be an Indian company. So the weightages for the transferee company, a question may arise from there, mind you. There are a number of case laws like Guarantee Estate case law. I can speak on this case on Brandbacks Limited case law is there, and you have Reliance Industries case laws, in which the law gives permission to the Honorable Court. The law empowers the Honorable Court to make alteration in the scheme of amalgamation, but the Honorable Court has not been empowered to insert new clauses into that which is not been considered by the shareholders. They have the power. The law gives under section 231 gives the power to modify the scheme, but the modification means that is in the best interest. But the jurisprudence does not allow to include new clauses which the shareholders or creditors even had not been think about. And amalgamation scheme should not be rejected on business reasons. So if I can speak through the case laws, I will speak and go. But fundamentally, I will conclude this class by saying that public interest is the crux of approving scheme of amalgamation. No creditors should be defeated. The intention of the law should not be defeated. The defrauding creditors will not be promoted, and ultimately public interest should be protected. Friends and students, this is my portfolio for today's video, and you can request topics to my email ID or through my phone number. This may be available, and I will take specific topics specific wise, overall view and study plan. But with this video, and if you look into the study material or your private material, what you have, you'll get the idea. But fundamentally, I will say section numbers is very important, form numbers is very important, and case laws is very important when it comes to CA final. And take charge of the same. Take care. Thank you.